When a medical procedure goes terribly wrong, your head is just spinning with questions. But there's usually one that cuts right through all the noise. One very practical, very urgent question that you need an answer to right now. So let's dive into what that question is and how Indiana's pretty unique laws give a very, very specific answer.
What is my case worth? I mean, that's the bottom line question, isn't it? And in Indiana, the answer is shaped by some of the most restrictive laws in the entire country. It all really starts with one single number that you absolutely have to know from the get-go.
$1.8 million. This right here? This is the single most important figure in Indiana medical malpractice law. It dictates, well, pretty much everything. But what does it actually mean?
It's a hard ceiling, a strict limit on what can be recovered. And get this, no matter how catastrophic the injury is. So let's break down exactly how this cap works and what it means for anyone trying to navigate this incredibly difficult process.
So our first stop is really digging into this cap because, honestly, it's the most critical factor that influences how every single claim is valued and negotiated here in the state.
So what is a damage cap anyway? Well, it's a legal limit set by the state on the total amount of money a person can receive. And this is the part you really got to understand. It applies to everything, all combined. We're talking medical bills, lost wages, and pain and suffering. Even if a jury came back and said this is worth $10 million, a judge is legally required to knock it all the way down to this cap.
Now, this $1.8 million figure is actually pretty new. The cap has gone up over the years, which is exactly why the date the malpractice happened is so incredibly important. See, if it happened before 2017, the limit was way lower. But for any incident on or after July 1, 2019, we are looking at that current $1.8 million ceiling.
Okay, so if the biggest payout you can get is $1.8 million, the next obvious question is, right, where does the money come from? And it's not as simple as a doctor or a hospital just writing one big check. Indiana has a very specific system for this.
It's a two-tiered system. So first, the healthcare provider's own insurance is on the hook for the first $500,000. After that, a state-run fund, it's called the Indiana Patients Compensation Fund, or PCF for short. That fund covers the rest, all the way up to that $1.8 million limit. What this means is you're often looking at two completely separate rounds of negotiations to get the full amount.
So we know the max amount, and we know who pays it. But what exactly is that money supposed to cover? Well, the law breaks down the total cost of an injury into two really distinct categories. I really like how this slide frames it. On one hand, you have economic damages. These are the direct, calculable financial costs, the stuff you can put a price tag on. And on the other hand, you have non-economic damages, which represent the deep, intangible human losses. Economic damages, these are the things you can literally put on a spreadsheet. We're talking about every single dollar for surgeries and hospital stays, the projected cost of a lifetime of future care, and, this one's huge, the loss of all the wages a person would have earned over their entire career if they hadn't been injured. And this just perfectly shows the other side of the coin. Non-economic damages try to put a value on the human cost. This includes the physical pain, the mental trauma like PTSD, being unable to enjoy your hobbies or, play with your kids. And it also includes the devastating impact an injury can have on a person's relationship with their spouse and their family. And remember, both of these categories have to fit under that one single cap.
Now, before a case can even get close to a courtroom, there's this mandatory roadblock. Every single malpractice claim in Indiana has to pass through it first. It's called the Medical Review Panel.
So what is it? It's basically a panel of 3 healthcare providers from the same field as the person being sued, plus an attorney who's kind of like the chairperson, but they don't get a vote. Their only job is to look at all the evidence and give an expert opinion on whether the proper standard of care was met. And you cannot skip this step. It's required.
And this process, well, it takes time. A lot of time. Just look at this timeline. After a claim is filed, just the medical review panel part alone can take anywhere from 18 months to 3 full years. This is not a fast journey by any means. Now, the panel's opinion isn't legally binding. You can still go to court even if they rule against you, but it carries enormous weight. A favorable opinion can really push the other side to settle, but an unfavorable one, that can be used as expert testimony against you in front of a jury, making your case so much harder to win.
Okay, for our final section, we need to cover just a few really crucial rules for specific situations, and also the single most important deadline in this entire process. You have to know this one.
In the absolutely tragic event that malpractice leads to death, the rules can change. If the person who passed away had a spouse or dependent children, the family can typically access that full $1.8 million cap. But if the adult had no dependents, non-economic damages can be severely limited, sometimes to as low as just $300,000.
And this brings us to the final, and I would argue the most urgent piece of information you need. Is there a deadline? Is there a time limit to take action? The answer is a loud and clear yes.
2 years. That's it. This is the statute of limitations. And let me tell you, it is an unforgiving, absolute deadline.
So, the crucial point is this. You must file your complaint with the Indiana Department of Insurance within 2 years from the date the negligent act happened. If you miss this window, the door to seeking justice, it closes permanently. And that really just sums it all up, doesn't it? Navigating a malpractice claim in Indiana means you're dealing with two incredibly powerful forces: a fixed price tag on a life-altering injury and a strict 2-year clock that starts ticking the moment the harm is done. It just leaves you wondering, in a system with such a hard ceiling and such a short deadline, how is the true cost of a human loss ever really calculated?